Start. A perusal of the aforesaid orders would clearly indicate the extent of which the litigation that had been decided earlier between the parties stopped. Thus, the dispute boiled down to an ossification test to be conducted for the purpose of assessing the actual age of the appellant in order to determine as to whether he deserves to be superannuated or not. According to the learned counsel, no such ossification test appears to have been carried out, nor there is anything on record to indicate that any ossification test was actually carried out. There is no report available so as to ensure the compliance of the aforesaid direction of the High Court. Para. It is in this background that an order was passed by the District Inspector of Schools on 7/6/1997 calling upon the institution to superannuate the appellant staff. The principal, who is the appointing authority of Class 4th employees under the regulations framed under the UP Intermediate Education Act, 1921, proceeded to pass the order of superannuation of 18/6/1997 in compliance of the said directions of the District Inspector of Schools. Para. The principal also intimated the aforesaid action taken, to the District Inspector of Schools wide letter dated 25/6/1997. Para. It is thereafter that the litigation ensued and the orders were passed. The District Inspector of Schools passed a fresh order on 26 April, 2008, wherein it was held that according to the material available on record, the appellant had obtained orders from the civil court by concealing material facts, and even otherwise his physical appearance would also indicate that he was above 60 years of age. It was further held that the copy of the family registered indicated that the month and year of birth of the appellant was August, 1933, and accordingly he had already attained the age of 64 years. In the wake of the aforesaid evidence, it was finally held that the deceased appellant Vijay Singh had attained the age of 60 years, which is the age of superannuation of Class 4th employee in 1993 itself. It is this order which came to be challenged in the writ petition giving rise to the present appeal. Para. During the pendency of the writ petition, the appellant Vijay Singh died and he was substituted by the second appellant number 1/1 before this court. The writ petition was dismissed, treating the facts relating to the age of the appellant to be raising disputed questions of fact. Since, it was not possible to adjudicate the said controversy in a writ petition, coupled with fact that the original petitioner had died in the year 2011, the court did not find it appropriate to exercise discretion in favor of the heir of the deceased appellant. Para. Certain doubts have also been expressed in paragraphs 6 and 7 of the judgment that even if the issue of the service book being fake and manipulated is ultimately found to be against the appellant, the same may incur a criminal liability. Para. Learned counsel submits that criminal liability cannot be of the appellant in as much as the service book was either in the custody of the employer or of the employee, and the appellant being only the heir of the deceased, he cannot be charged with any offense in as much as the document had been filed by the original petitioner and not by the appellant.